Deliberately causing harm. In this video we're going to explore the legal consequences of deliberately causing harm to another person. This includes not only deliberately causing harm to another person in a business context, but also causing harm in a personal context. If your conduct causes harm to another person and that conduct is not justified or excused by law, there will be legal consequences. The consequences can be criminal consequences and or civil consequences. So for example, if I were to punch another person in the face, there will be criminal consequences. That person could complain to the police, I could be charged with a criminal offence, I could be tried, and if I'm found guilty I could be punished in some way. But the same act could also give rise to civil consequences. The person who I harm could commence civil proceedings against me. They could sue me for compensation. The same act can give rise to both criminal consequences and civil consequences. In this subject we focus upon the civil consequences of causing harm. The person harmed commences legal proceedings against the person who caused them harm. The person harmed, if they're commencing legal proceedings, is usually referred to as the plaintiff, and the person who did the harm is the person being sued, and they will be referred to as the defendant. The particular area of law that we're focusing upon is tort law. Tort may be a new word for you. The definition of a tort is a civil wrong other than a breach of contract. So by civil wrong we mean an act that causes harm to another person that gives rise to the possibility that the person harmed could commence civil proceedings. So let's look at the law of torts. While the word tort may be a new word for you, I am fairly confident that you will already be familiar with a number of the torts that we're about to look at. So the first tort is one that you are certainly going to be familiar with, and that is the tort of trespass. Trespass is direct and intentional interference with the person or property of the plaintiff. There are in fact different types of tort. There's trespass to land, trespass to goods, and trespass to the person. So let's begin with the tort of trespass to land, which is again one with which I am sure you are already familiar. A person commits the tort of trespass to land if they interfere with another person's exclusive possession of land. So if I come into your home without your permission, I commit the tort of trespass to land. Even if you're not the owner of the land, you are simply a tenant, you are still the person who has exclusive possession of the land, and so if I come onto your property without your permission, I am committing the tort of trespass, even if I am the landlord. Now land includes not only the surface of the land, but also the airspace above the land to the height reasonably necessary for the use and enjoyment of the land. In the case of Kelson and Imperial Tobacco Company Limited, the material facts were that the owner of a property installed on the side of their building a billboard, and that billboard actually extended across the boundary of the neighbouring property and into the airspace of the neighbouring property. The legal issue was whether or not that billboard was trespassing on the land of the neighbouring property. The court's decision was that the intrusion into the airspace above the neighbouring land was a form of trespass to land. The second type of trespass is trespass to goods. A person commits the tort of trespass to goods if they interfere with another person's possession of goods. So if I take your textbook without your permission, I am committing the tort of trespass to goods. Similarly, if I damage your personal property, or I borrow your personal property with your permission but I refuse to give it back, all of these are examples of trespass to goods. And there is trespass to the person. A person commits the tort of trespass to the person if they interfere with or threaten to interfere with the body of the other person. There are different types of trespass to the person. So there's the tort of battery. A person commits the tort of battery if they cause some sort of physical interference with the body of another person. So if I punch you, slap you, shoot you, stab you, all of these are examples of the tort of battery. The merest touch can be battery. So an unwelcome kiss or hug can be battery. On the other hand, the courts have made it clear that no one is entitled to insist upon living in a bubble and insisting that no one ever touch them. The courts have explained that we are all expected to put up with a certain minimal amount of physical interference as part of living within a community. In Rickson and Star City Proprietary Limited, the material facts were that Mr. Rickson was not supposed to be within a casino and was approached by a security guard who touched them on the shoulder in order to get their attention and asked them to leave. The question was whether the touching on the shoulder was the tort of battery, and the court's decision was that that level of physical interference fell within what could be reasonably expected as being part of day-to-day life, and the actual touching was not battery. The second type of trespass to the person is the tort of assault. Assault in criminal law is the actual physical interference, but in tort law, assault is the threat of physical interference. If I cause you to reasonably apprehend or reasonably anticipate physical interference, then I have committed the tort of assault. So, for example, if I wave my fist under your face and threaten to punch you, or I'm waving a weapon around in a way that makes it look like I'm about to discharge the weapon and cause you physical harm, then I am committing the tort of assault. I'm committing the tort of assault even if I can't actually carry out the threat. As long as you reasonably believe that I can carry out the threat, I have committed the tort of assault. And the third type of trespass to the person is the tort of false imprisonment. A person commits the tort of false imprisonment if they cause another person to be totally restrained. So if I were to lock you in a room against your will, I commit the tort of false imprisonment. The tort of private nuisance is committed if a person indirectly interferes with another person's use and enjoyment of private land. So, for example, if I am your neighbour and I am playing loud music all night, keeping you awake, I'm not actually trespassing on your land, but I am interfering with your use and enjoyment of your land, and I'm committing the tort of private nuisance. A person commits the tort of public nuisance if they indirectly interfere with another person's use and enjoyment of public land. So, for example, if I do something that blocks the road in front of my business, or I do something on my land that causes people using a neighbouring public park to be interfered with. For example, if I'm emitting noxious fumes from a factory on my land that is causing people who are using the nearby park to not enjoy the use of that park, then I'm committing the tort of public nuisance. The tort of defamation is another tort that you may be familiar with. So defamation is committed if a person publishes to a third party in spoken or written form a statement about another person that would damage the reputation of the other person. So we sometimes refer to defamation as libel or slander. Libel is written defamation and slander is spoken defamation, although in the eyes of the law there's no legal difference between the two. There are three requirements that you would have to establish if you wanted to commence proceedings against me in the tort of defamation. First, you would have to show that the statement I've made about you is defamatory, and by that we mean it's something that would reduce your standing in the eyes of other people. Secondly, that the statement identified you, either by name or by some kind of description. And thirdly, that the statement was published to a third party. So I've actually said that defamatory statement, or I've written that defamatory statement, and another person has heard or seen it. So if I say something to you and there's no one else around and no one else to hear it, it can never be defamation. Defamation must be published to a third party. And here published doesn't just mean published in a commercial publication. Published includes any form of communication. We do, however, live in a liberal democracy that values freedom of speech, so there are a number of situations where what appears to be defamation isn't a defamation because there are defences available. The most well-known defence to the tort of defamation is justification or truth, and that is where the defamatory statement is in fact true. There's also absolute privilege. Politicians, while in Parliament, cannot be sued for defamation. So they're free to say whatever they like about other people, and similarly judges while behind the bench have absolute privilege and cannot be sued for defamation. Another defence is honest opinion. If I make it very clear that I'm simply expressing an opinion about a public matter, then I can't be sued for defamation. Defamation applies usually to statements of fact, not statements of opinion. We have the tort of deceit, and the tort of deceit is committed when one person essentially deliberately lies to another person in order to cause them harm. So the requirements here are that the defendant made a statement to another person knowing that it was false. They made the statement with the intention that it be relied upon the other person relied upon the statement, and the other person suffered harm as a result of relying upon the statement. If all four requirements are satisfied, the tort of deceit has been committed. And finally, the tort of passing off. This may again be a new term for you, but it's not necessarily a confusing term. The tort of passing off is committed if I make it look like the product that I'm trying to sell is associated with a well-known business or has the endorsement of a well-known celebrity. So this is a business tort that has three requirements. First of all, that the defendant has made a representation that their goods or services are connected with another person or have the other person's endorsement or approval. Secondly, the misrepresentation is made in the course of a trade. And thirdly, the misrepresentation is intended to deceive potential purchasers. So for example, if I have started a small business that sells chocolate, and I package my chocolate in such a way that it looks just like Cadbury chocolate, then it's likely that Cadbury will sue me in the tort of passing off. I am misrepresenting an association with their business. In Pacific Dunlop and Hogan from 1989, the material facts were that Pacific Dunlop used a character that looked very much like Crocodile Dundee in a scene that was very similar to a scene from Crocodile Dundee in order to sell their shoes. Legal action was commenced against Pacific Dunlop by Paul Hogan, the actor who plays Crocodile Dundee and who in fact owns the rights to the character Crocodile Dundee. The legal issue was whether or not Pacific Dunlop's use of that Crocodile Dundee character without Paul Hogan's permission amounted to the tort of passing off, and the court's decision was that the elements of passing off were satisfied and that Pacific Dunlop had in fact committed the tort, entitling Paul Hogan to compensation.